Welcome back to AM Prime, ladies and gentlemen. Thanks for being with us as we continue with our conversations. So earlier this week, I had Karen Younes to share on the program as we were speaking of what took place in the Privy Council last week by the appeal brought forward by the Minister of Finance against the Auditor General, General Tiranda, seeking judicial review. That, of course, that appeal was thrown out by the Privy Council, so the case moves forward. But there are still some question marks surrounding the entire case. And Karen returns to AM Prime this morning. She's 3 days in a row, Karen. You got AM talking point yesterday. And welcome back to the program this morning. Thanks for being with us, Karen.
Well, I'm very happy to be here with you this morning, Keaton, and with your listeners. And, your colleague really did make a strong point. He says, this might be seen to be an isolated case, but it is not, because it is an attack on the sanctity and the constitutional independence of a public office that is so important to our country. So I'll go quickly. We went through what judicial review is. It only applies to public officers, and you are saying it. You're asking the court for leave, a permission to review the decision of a tribunal, public office. It could be control of customs. In this case, it would be the Minister of Finance, and to have it reviewed, and ask for leave to get that review. And you have to have certain grounds, which I won't go into all of them, but there are some of the unreasonableness, excess of jurisdiction, etc. And so she did apply, and she was not successful at the High Court. She went to the Court of Appeal. The Court of Appeal said yes. Because, one of the reasons is, and I want to make that very clear, the threshold, there's 2 points about it. The threshold for getting leave for judicial review is a low threshold, but that's not the end of it. It is also the fact that it's not only the threshold is a low threshold, but in order, the test that they apply to determine whether you have met that low threshold, which I think should be something that the minister should take into account, is whether, and this is coming from the Privy Council decision in the Sharma case, Sharma versus Brown and Twine, and also another Privy Council case involving Air Caesar. And what they said, very briefly, is whether the applicant has an arguable ground for judicial review which has a realistic prospect of success. That is what the test is. So you understand that if they give her, she has been given the leave for judicial review, it means they are satisfied that if the matter goes and it is remitted before another judge, which is what is the outcome of her leave being granted, is that they are satisfied, applying that test, that it has realistic, not reasonable, realistic prospects of success. That's the language that was used in the case that Privy Council case in Sharma versus Brown and Twine. So we set the stage. Now, what had happened on the last occasion, and please interrupt me at any time, what had happened in the last case is we know the Auditor General's duties is set out in the Exchequer and Audit Act, and it's very clear. She's like other auditors, but she's the Auditor of Public Accounts. And that includes, and it comes from the Treasury, and the Treasury is defined as the Ministry of Finance. So it's the Minister of Finance who collects all the statement of expenditure, statement of revenue, and other documents that he must submit. And the deadline would have been the 31st of January. That deadline was met on the 31st, but then subsequent to that, they then said that, we made some mistakes and so on. I'm sorry about that.
No worries.
Yes. Oh my God! I thought I would have gotten the person to stop.
It happens.
Oh my God! Sorry, I thought I took off my I took off my thing. Anyway, so the point is that so the question was that she had her report were ready, and her report was ready within the time frame set out in the Constitution now, and the Exchequer Audit Act together. And the deadline would have been the end of April. She submitted it on the 24th of April, but in it, according to the Constitution, when the Auditor General is prepared with the Auditor General's report, it is then given to the Minister of Finance, the Speaker of the House, and the President. But I just want to say that you can look at Section 9(1) of the Exchequer and Audit Act, but even what she has said herself, and you can go to the website, and it reflects exactly what her duty is. The purpose of the report, this is what she says, and it's said in the legislation, The purpose of the report is to ensure that there's transparency, accountability. The Prime Minister liked that word when it came to Mr. Hart. Transparency, accountability, and good governance. It is this report that lawmakers and the public turn to for assurance that the government is acting in a transparent, ethical, and lawful manner, and that the financial reporting accounting systems in place accurately reflect the financial performance of the government. The country's international reputation could be adversely affected by an unreasonable delay in submitting the report, etc. And she's borne out, and I won't go through it, by Section 9.1. This is exactly that is her responsibility. But Section 9, as I already said to you on the last occasion, 9.2 says, well, how is she going to determine that? Like any auditor, independent auditor, you've got to give her the documentation, and it actually says that she needs that. It must be supported by sufficient vouchers and proof of payment to make sure the payments were properly chargeable. That's all she wanted, and she clearly was not given that. So eventually, on April 24th, she did send up her report, which is 6 days before the deadline. But in it, and I suppose that is what set off this whole kerfuffle, as our current president of the United States might have said, she added what you might call a qualified report, because she said at the end of the report, it's called a disclaimer, that's what she called it.
Right, this is the disclaimer
in the report, right, and that is what he saw before. Remember, they saw it on the 24th, he, the speaker, and the president of the Senate, but it's sent to them in advance. This is what she said: I was unable to obtain sufficient appropriate audit evidence to form an opinion on whether all revenues have been fully accounted for and included in the public accounts. I was unable to determine whether any additional adjustment might have been found necessary with respect to recorded or unrecorded revenue. As a result, the completeness and accuracy of actual revenue could not be ascertained. Audit procedures were hindered as supporting documents were not provided to verify payments. As a consequence, expenditure of $1 billion could not be verified. So you understand, she put that in that report. He has no authority to tell her she can't do that. The Constitution says that's what she must do. And further, the Constitution says that within submitting her report, in the next sitting of Parliament, the report must be submitted and submitted to the Parliament. Well, what he did, he asked for, made a resolution to extend the time. That's usually done before the 31st of January because you don't think you'd meet the deadline. But of course, in my view, having seen that, he wanted to buy time to do something. And the something he did was set up what they call is this investigative committee headed by a retired judge, Justice Harris. And you look at it to the references. Well, when I spoke about it on another show, your colleague, and I read out the terms of reference, it was very troubling because it almost came to a conclusion that it was as if the Auditor General was irresponsible. The Auditor General had done the understatement. The Auditor General had given the public the wrong information because it says what circumstances led to the understatement of revenue. So you've come to a conclusion. Understatement of revenue of public accounts for financial year 2023 and what should be done to avoid same. The efficacy of the electronic clearing system. Now, with regard to the argument was that the decimal point was put in the wrong place with the expenditure. So the expenditure was shown to be 25 billion when it was only 25 million. So when they made the adjustment, it increased the revenue position from 61 to 63 billion. I'm just simplifying it. And that electronic clearing system, which is something the central bank had just initiated in February, I believe.
Yes, yeah.
She had asked, and they didn't report it completely. She asked if she could meet with the central bank governor and also review the system. That is her job. He said she couldn't review it. Well, I saw the letter, and they said she couldn't review it. They said she could come, but she couldn't see the system. But why can't she?
Was any reason given as to why she was not allowed?
No, there's a very short letter, if I can recall. Something being corrected. I saw the letter, it was very short, no explanation. Why wouldn't you let her see it? I mean, let her see it because that if you're saying that's the cause of the problem, and her responsibility under the Constitution and the Exchequer Audit Act is to audit to make sure that you can verify what you're saying to be so. Let me see the system. Why don't you want me to see it? So, in any event, the efforts made by the officials at the Ministry of Finance and its various division to correct the understatement. So everything seemed to be like, oh, we are the Ministry of Finance, did everything thing, and this lady is giving trouble. That is the way that terms of reference seem to read. And that's how the Privy Council took it, because as you know, repeating, Lady Simler said several times that the lawyer representing the Attorney General, who made the appeal decision of the Court of Appeal, who found in her favor that she was entitled to relief for judicial review of the decision of the High Court. So he was honest, he couldn't take that decision. So he went went now to the Privy Council, and the Privy Council gave him a little harder time through his counsel by saying you couldn't come. Where's the knockout blow? Couldn't answer that. Why isn't the Minister of Finance part of this terms of reference?
Suggesting bias, yeah.
And she asks it over and over again. If you don't understand what she means, well, you have to know that she's saying, we haven't got any written report because she said it was so important. They listened to it for 2 hours, rose for 10 minutes, according to the report in the papers, came back and said, we don't need to hear your lawyer. We already know the decision, review, granted. And what is also noteworthy, as far as I recall, there are 2 cases that she had, which is going to come up a little later, a few days later, against the Attorney General, because the Attorney General said to her, when she came to him under the legislation, the Exchequer Audit Act, Section 10, she can go to the Attorney General, who is supposed to be advisor to the government, not to a minister, not to a particular minister, to any public office. She's a public officer. And he said that he couldn't do it, but she could they would pay for her opinion on the amended statement, whether she should submit it, but that's the end of it. So he wanted her to take on the cost of any challenge with those very deep pockets of the state. And what is noteworthy is that the Privy Council also said that costs should be awarded to her for senior counsel, junior counsel, instructing attorney on an indemnity basis. So I don't know if the Attorney General going ahead with the case, because if I was that, I think they already made up their mind that they're supposed to pay for.
But Karen, let me ask you something. In respect to the Hires Committee that was set up to investigate this entire imbroglio, why is it that the Minister of Finance saw it fit to go down this particular avenue?
Okay, so this is and now everything, there's something called fair comment. So I'm covering myself with that, a fair comment. And that is because under the Constitution was created that post of Auditor General. One of the things, of course, it would have been concerned about is political or other interference, because it's a serious job. I mean, in other words, they could send anything to her and she's just supposed to accept it. But when you don't need her, then she's redundant. She's there. She's the gatekeeper for us. This is not their money. It's our money she's gatekeeping. And why he would have done that, to answer your question, more thing, under the Constitution 116.6, it says the exercise of his functions, his inclusive, under the Constitution shall not be subject to direction or control of any person or authority. So that created a problem. Unlike with the central bank governor, who has no independence of office, and of which he lost his case, by the way, and in which the central bank governor was awarded significant damages for a wrongful dismissal by that same Minister of Finance. There was no protection. This is her constitutional protection. So I don't think he was happy with her, and at all, to put it mildly. And these are some of the reasons why she said that the terms of reference and the whole way in which this Harris-headed investigation committee was questionable in terms of going after, because you're looking at, also the things you look at is fairness, justice, fairness, whether it's motivated by malice, Or, you look at these kinds of things when people, when you go for leave for judicial review. So when you look at it, these were the arguments that they were put forward. Number one, the involvement of the Minister of Finance himself. He initiated the investigation. He selected the members of the team. He determined the terms of reference as they related to the Auditor General. He assumed responsibility vis-a-vis his ministry for remuneration of the investigating committee. And finally, he required the team to report to the minister himself. So when you see that, you want to ask yourself, well, what is he about? I mean, why do go to all that trouble? Someone said, I think the opposition leader said, doesn't it seem like a waste of time? Well, no, maybe not, because this is what happened. Now, since you can't touch her that way under 116(2), you can't touch her. She's insulated, just like the DPP is insulated. Some officers are insulated. However, that doesn't mean she can't be removed. And how do you remove her?
Really?
No,
if she's insulated, it suggests that she can't be removed. But you're saying
no, but any officer can be removed under
right?
certain circumstances. So therefore, if you couldn't remove her that way, then the first step one might think is, well, let me set up an investigative committee. And if this investigative committee brings a report to us that shows some wrongdoing on her part, shows some dereliction of duty on her part, some sort of thing that would make her unfit to be hold the office of Auditor General. Let's just say, for argument's sake, given the terms of reference, which even the Privy Council questioned, why wasn't he part of the terms of reference? This is what Section 129 of the Constitution, and it applies, 129(11) says it applies to the Auditor General. It clearly says that. And the person to do the removal is the president. That's why you need an independent president, because you know who appoints the president, Prime Minister. So under the 129, it says it is that the president, either on her own initiative or either on the either on her own initiative or on the prime minister, or at the request of the prime minister, can establish a tribunal for the purpose of determining removal of office. And Section 129(9) talks about the appointment of the tribunal, and is appointed by the president again. And she appoints the chairman and no less than 2 other persons on the advice of the Judicial Legal Service Commission. Well, it is true, the Judicial Legal Service Commission is not appointed directly by her, but the chair, who is the Chief Justice, is appointed by the Prime Minister. And 129,
what reasons?
And this goes on. It says 129(12), it says, clearly, this applies to the Auditor General and such other officers may be prescribed. And it says that the tribunal shall inquire into matters and report on facts to the president and advise whether the officer should be removed on the grounds specified in 129(7). So what are the grounds? The grounds are inability to discharge the functions of his office as a result from infirmity of mind or body. This is the key part. Or any other cause, or for misbehavior. Yeah, what is that? Or any other cause.
So hold on, Karen. Correct me if I'm wrong, and I'm not trying to be facetious here. But the president could simply say, I don't like you, you're gone. And that can happen because that's what any other cause suggests.
But what it says is that the president has the authority on her own initiative or the advice of the prime minister to set up a tribunal. If other officers can be done, but we're talking about the Auditor General. And it says in 129(11) that this section applies to the Auditor General. So it's set up a tribunal. So it's a tribunal that has to be set up to make the determination. But in setting up the tribunal, the president selects the chairman, and the president selects no less than 2 other persons who sit on that tribunal on the advice of the Judicial Legal Service Commission, which is headed by our Chief Justice, who is appointed by our Prime Minister, by the way. And they then go now and determine whether I am assuming if the Harris investigation team had submitted a report to the cabinet. And the cabinet said, well, there's enough grounds here to set up a tribunal. We need to set up a tribunal. And then we will set it up under Section 129. And when we set it up under Section 129, we could remove her. Because we could remove her if the tribunal is of a view, as I read out to you, infirmity of mind or body, misbehavior, or any other cause. So that is a circuitous rounds, but the only way, if that is in fact the reason behind setting up the tribunal, because you had to sit down and think, if it is that they wanted to get rid of her, because she also filed a special report, and that must have hurt them hard, because the special report, I have to mention, they didn't do it out of the kindness of their heart, and anybody could go to the website and they'll find it, okay? They had to set up, she was given opportunity to explain why, in effect, she gave a disclaimer to her report. That's what it amounted to. And Section 25(4) of the Exchequer and Audit Act, so it's not her deciding these things. This is the legislation. It says the Auditor General, that's 25(4) of the Exchequer and Audit Act. It says the Auditor General, if at any time it appears to him desirable to transmit a special report to the Minister for presentation in like manner to Parliament, such special report may be made incidental to his powers and duties under the Act. So she exercised her powers under Section 25(4). This is after the Harris Tribunal had been set up. This is after they had set this up and set out the terms of reference. She then exercised her powers to let them understand what she meant. I am assuming when she said what she said in disclaimer. So you want me to be more clear? And if you read it, it's there for everybody to read. I read it, She gave a number of reasons. And it's very worrying, actually, when you read it. She gave a different heading, monthly monitoring and reviewing. She said they was not signed off by the internal audit as evidence of certification by the accounting officer on documents examined as per in contravention of the Control of Accounts directions. Authorization, no evidence and adjustments dated May 14 was signed by the Control of Accounts to authorize changes to the general ledger account, which is the debit and credit account. All adjustments, the vouchers, to refund totaling 2.599 billion, which is the 2.6 billion we're talking about, were reviewed. However, none was signed by the controller of accounts as required. She talked about the segregation of duties, no evidence of debit advice slips prepared by the controller sent to the chairman of the Board of Inland Revenue were examined for unusual or material transactions. I think 2.6 billion would qualify. Signatures of preparation, checking, reviewing, and approving of debit advice slips were not seen by them or documents examined. Audit could not determine who prepared, who checked, and who reviewed the debit accounts. And she talked about proper recording, inability to produce accurate and complete accounts for the financial position for 2023. Accounting books and records in the Ministry of Finance were not finalized. So at the end of the day, she gave other reasons. She concluded, ineffective internal audit, absence of management oversight may have contributed to non-compliance with the legislative requirements of the Exchequer and Audit Act. That is her special report.
Karen, there are two things from this. One,
I'm shocked by what I told you.
Yes, because it has me, you've been following this case, you've broken it down brilliantly, and I thank you for that. Not to digress from the topic at hand, but from what you explained, even with respect to the president and the powers that the president has, and why you made the argument this is why we need an independent president, it suggests that the prime minister now has absolute power. The prime minister can do as he pleases because of the chief justice, because of the president existing there. So that's just one point raised. But the second thing is, and this is where I want your opinion now, do you think that this entire process, even with the Minister of Finance, creating this committee on his own, coming up with the terms of reference on his own, appointing members of the committee of his own, And then, of course, the Privy Council deliberating for 10 minutes. For 10 minutes, if it was so much. Was this a waste of time and money? Was this a waste of resources?
Well, in one sense, one can say that. But by the way, um, it's the Minister of Finance through the cabinet, and that's how it's worded, because the cabinet had to give the approval, but all the initiative of everything came from him. But it is through the cabinet, it is. So it's the Minister of Finance and the cabinet, but it's really the minister. So what is the question you ask? What's the point of giving the Auditor General and other public officers who are so important to our democracy, and you deliberately give them that insularity from political interference and for good reason? You go to all that trouble, yet you see acted out, and I can't say for sure because but you have to ask yourself, what's the purpose of the Harris investigative report? And even the Privy Council couldn't understand why is he not being investigated too? Because he don't want himself investigated. He wants to be investigated because he wants to get a report. And when he gets a report, I have to assume, I mean, it's only reasonable. If it's wrong, it's wrong. But oh my goodness, what else are you to think? If you can't touch her under 116.6, and that may frustrate you, because you could get rid of the central bank governor. You lost, but you could get rid of him because he did not have independence as the DPP has, as the Auditor General has. So how am I going to get rid of this lady? I mean, that is what has to come to your mind, because why set up this thing, and why it is that the Privy Council is concerned that you are not part of it. Shouldn't you be investigated? Because I think you should be investigated. Why are you sending, you are the Treasury, by the way, in the Exchequer and Audit Act, Treasury is defined as the Ministry of Finance, you know. You sent it, why didn't you, when you sent it the first time and realized that something was wrong, because that's what your PS said, and said we miscalculated, you know, it's really supposed to be 64 billion, not 61 billion. Wouldn't you, as a Minister of Finance, go and check with the Controller of Accounts, the Board of Inter, find out where the mistake was? And then when you find out where the mistake is, say, my God, you all have fallen down on the job. You all have fallen down on the job. This is absolute delinquency, this absolute incompetence. We are to blame for what has gone wrong. If the Auditor General says that she needs vouchers and she needs proof, well, if she is now telling us now, well, that's why she couldn't do it, because you couldn't give her the proof. And when she asked to see the electronic system, which, I mean, you know, the central bank office has been reduced from 5 to 3 years, right? When you can't get to see that, he tells you, yeah, you can come and see me, but you can't review the system, which you saying it caused the problem with the decimal point. When you're doing all of that, should I ask the court, should ask the investigating Minister of Finance? Should not on the 31st of January, yeah? But by the time you realize there was a mistake according to you, and that, oh, by the way, we made a mistake, just check, correct it. No, that is not her job. Then she's redundant. You don't need her. You do your own thing. That's her job. And if you don't want her to do that, then why are we not investigating you and your ministry to find out what y'all were doing inside there when you realized you had made a mistake? And look at the number of errors she pointed out in her special report that makes you wonder what was going on inside of there, that things were not being done. Shouldn't you investigate yourself? Because investigate anybody to be and I think that's what that's what the Privy Council really trying to say, you know. Because I understand it, because I don't want anybody to misunderstand me. The 31st of January could generally be an error that he was not aware of. Okay, I give him that pass. But by the time you come and have your PS right and say, oh, by the way, we made a mistake. And by the way, they could not, 870 billion, it started with 3 point something billion, but it went down to 2.6. Oh, nearly, because they couldn't get 870 million, and they gave that up, right? By that time, you knew there was a problem, and you knew the problem emanated from your ministry, Inland Revenue, Control of Accounts. You knew that's where the problem emanated. Instead of taking responsibility for your incompetence of your ministry, because you are the head of it as the head of Treasury, instead of taking that, you want to put it on her, hoping that she would shut her mouth, not say anything in the disclaimer. When he saw that, he must have been beside himself, because that resolution to extend the time is done before you send in the report, not after you send in the report. And then he set up a Harris thing. For what purpose? For them to come back and say they found a cause to show why she should, the president should be recommended to the president a tribunal to be set up under Section 129. I mean, that's how it's looking.
But
That's how
Karen,
it's looking.
we're reaching to that end point.
I hope I'm more helpful.
I know I will tell. No, you have been very helpful, but the thing is, it concerns me even more now. At the time this has taken, the resources that it has taken, it's gotten all the way to the Privy Council. For then, lawyers have been paid, assets and resources have been everything, and of course, this is what
And
happens.
the purpose, why did you set up that, Harris? You couldn't get rid of under 116.6.
Yeah.
Why you set it up? The law lords asked you, why are you not a subject of this investigation? You should be, your ministry should be part of this. So all of that, it's
But
really
Karen,
troubling.
the case continues. The case goes on. We will see what happens next. But at this point, Karen, I want to thank you very much for your
Oh
time
my God.
and for breaking it down for all the elements, starting on Tuesday and of course, continuing and concluding this morning. Thank you very much, Karen.
And just to tell you, I would invite your listeners to go to the Auditor General's website, because when they go there, they will find the special report, they will find the Exchequer and Audit Act, they will find all the documents that are independent legislative documents that would assist them in understanding. So they will have a better understanding on their own of the issues that we discussed today.
Indeed. Thank you so much, Karen. Thank you very much.
You're welcome.
All the very
right,
best.
bye-bye.
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 Well, ladies and gentlemen, what a program we've had this morning, and we thank Karen once more for breaking down all the elements of this particular case. It goes on, it continues, we will see what happens. And next, but at this particular point, it baffles me. It baffles me at times, just what happens in Transvago and the costs associated with this: time, resources, money spent. Ladies and gentlemen, that's it for AM Prime. Thanks very much to my guests for joining me this morning, and to you, the viewer, of course, for being a part of AM Prime and the conversation. To my team in studio, Rani Gomez-Burke and Milewood, thank you very much for your continued hard work and efforts. And of course, to Naomi McNish for producing AM Prime. I'm Keaton Shaw, reminding you today is a good day to have a good day. I'll see you again very soon. Bye-bye.